Okay, moving on. So, the next section of our class will be looking at instances in which genuine assent does not exist. These are when a contract might have consideration, legality, and the fourth element of capacity, but it might not have genuine assent, which is when, if you recall, the first element of a contract is mutual assent. And sometimes there's assent, but it's not genuine. Therefore, the law would count it as not being met, the mutual assent element. So the first type of lack of genuine assent is fraud, and we've covered fraud in multiple instances at this point. And I can't stress enough how important it is for a financial professional to understand the implications of fraud liability. So just to go over it again, fraud on its own in a contract context is when a contract is induced by an intentional misrepresentation or the omission of a material fact, and the contract is procured with those misrepresentations or omissions, and therefore the contract is voidable at the option of the person that was defrauded. So there's three specific scenarios with fraud. The first is fraud in the inducement. So this is when a defrauded party is aware of entering into a contract and intends to do so, but the contract is procured by fraud. So think about when somebody is intentionally deceived about maybe the value of a certain good. Maybe I'm selling a fake painting to you, is you were aware that you were going to buy a painting, you intend to buy the painting, but a material fact was misrepresented to you, where you probably were told that the painting was worth money and you bought it, and it's not. So this would be fraud in the inducement. It's on the procurement of the contract itself. So fraud in the execution occurs when the signature of a party is obtained by a fraudulent misrepresentation that directly relates to the signing of a contract. So this is when somebody probably lies to another party and gets the signature of that party, and it was a fraudulent misrepresentation the way that that signature was occurred, where maybe somebody didn't read the contract well. Maybe somebody pretended to be somebody else and signed it. This is just in the execution where the fraud exists. And lastly, there's a duty to disclose facts for all financial professionals. And by not doing it, it just constitutes fraud in general, right? So there's three scenarios. One is the parties have a fiduciary relationship. So that is between a CPA and a client, an attorney and a client, a financial professional with maybe a client, that kind of scenario. The second is one party knows a material fact and the other could not reasonably have discovered it. So this might be when somebody is selling a house and does not disclose that there are termites in the house that drastically lower the value of the house. Maybe one party knows about the termites and the other one couldn't have even thought about that existing. That is would be a breach of the duty to disclose facts. And lastly is an important fact is misstated. So maybe I'm trying to sell a house and I state that the house was built in 1999, but it actually was built in 1980. That would be a misstatement of an important fact. So the second category is simply misrepresentation. So there's two types of misrepresentation. There's negligent and there's innocent. So the negligent one is the one that most people need to be worried about, which is when there is a false representation of a material fact that was intended to be relied upon, but the person that said that representation didn't necessarily know that it was fake, but they said it without double checking. So this would be like, oh, the house is what like was worth 500,000 if you buy it, and I didn't know it wasn't 500,000, and it's actually worth 200,000. But I thought that it was 500, but I didn't act with due care. I didn't go and check the price of the house before representing to you the material fact that it's worth 500,000. So the remedy for somebody that gets hurt by relying on this sort of negligent misrepresentation is a claim for damages. And the person that's injured has to actually suffer some sort of loss and can only recover those damages for actual loss. So innocent misrepresentation is the scenario in which there was a false representation of a material fact, and there was reasonable reliance on that representation, but the person making the representation didn't know it was false at all. They had no knowledge of the falsity of what they were saying, but they actually believed it to be true, and they acted in a non-negligent manner, or a manner with due care. So generally, when somebody can prove that a misrepresentation was not an intentional misrepresentation nor a negligent misrepresentation, they can actually, if they prove innocent misrepresentation, then what happens is just that the contract gets rescinded. And sometimes there might be damages, but most of the time the contract just gets rescinded and there's no punishment for that person. And then we look into the third category of the lack of genuine assent. This is when there is a mistake about an underlying assumption of a contract. So this happens between both parties at the same time, and sometimes just by one party. So what is a mutual mistake? So a mutual mistake occurs when both parties to a contract are mistaken about the same material fact, but not value or quality. A mutual mistake of material fact is a basis for rescission or a sufficient defense for failure to perform. So let's see this example. So Katie has a truck that she uses for business. Kurt offers to buy Katie's truck. She agrees to sell. Kurt accepts her price and pays Katie. However, without the knowledge of either party, the truck was actually destroyed by fire a few hours before their contract was formed. Given that neither party was aware that the truck had been destroyed, a mutual mistake has occurred and rescission is available to either party. Pretty straightforward and self-explanatory. So here you have Katie who's selling a truck and Kurt who agrees to buy the truck. But when they were talking about this deal, they didn't know that the truck actually was destroyed. So they both made a mistake about a material fact when they entered into the contract. In this scenario, because they both actually were mistaken, the contract can be rescinded. Next, there's a unilateral mistake. What happens when it's only one side of the coin that actually makes a mistake about an underlying material fact? So this happens when one party to a contract acts on the basis of a mistaken belief or assumption. The party is generally not relieved of the contractual obligation. However, the remedy is rescission by the mistaken party in limited circumstances. So the mistake has to be material, and one of these four scenarios have to apply. So the first would be the other party knew or should have known of the mistake. The second is enforcement would result in extreme hardship constituting injustice. The third is the error was due to a mathematical mistake or omission of items in computing the cost of the contract, or the mistake was due to fraud, duress, or undue influence. So if you take that first example of mutual mistake, let's say only one person thought that maybe the person selling the truck thought that it was not destroyed, and then the other one knew it and entered into it. That would be a unilateral mistake. And usually in that scenario, the person that knew about it probably did so and entered the contract due to fraud. So that would satisfy the fourth scenario. Next is the lack of genuine assent when through duress. So duress is simply when one party uses an improper threat to effectively force another person to enter into a contract. When this occurs, the contract is voidable by the person that was the victim of the improper threat. So there's two types. There's the physical type, where it's a threat of personal violence. And then there's the economic duress, when one party exerts extreme economic pressure that leaves the threatened party with no reasonable alternative but to comply. So just taking advantage, though, of another person's financial difficulty is not duress. It's simply the extreme economic pressure. Maybe somebody is a boss and forces an employee, right, like through threats, to sign an unfair employment contract. In these scenarios, if there's no physical compulsion, then it's simply voidable, where the contract can still occur. If it's a physical compulsion, the contract never existed. Lastly, there's undue influence, the last scenario of the lack of genuine assent. So undue influence is similar to duress, but it's even higher in liability because it actually wrongfully exploits a confidential relationship. So just think of undue influence like duress, except there's a dominant party who's in a confidential relationship. So think lawyer, think CPA, think doctor, think psychiatrist. So if a contract was entered into while in a confidential relationship and it was done by a dominant party, then a contract is voidable on the part of the victim. So let's look at this example. So a confidential relationship existed between the client and the CPA that created an opportunity for the latter to control the creation of a trust. The CPA used the relationship to secure a change in the distribution of the trust assets to name himself as sole beneficiary. There were unnatural provisions in the trust documents, and the change in distribution did not reflect the true wishes of the client. The trust distribution is voidable as a result of undue influence. Pretty self-explanatory. You have a confidential relationship between a professional and a second party, and the professional uses the relationship to force the second party to enter into an unfavorable contract. The professional doesn't necessarily have to benefit from the change. They just have to use and exploit the relationship to enter into something that is unfavorable for the other party. So pretty straightforward. So here is the conclusion of our week 2 unit on contracts. I know it's a lot. There's essentially 3 classes in which we went over all of the legal doctrines for contracts. Remember, there's different types of contracts. There's ones that are spoken and done through conduct, and others that are implied by the facts. Remember that there's bilateral contracts, which are contracts between 2 parties, and sometimes there's unilateral contracts that say, if you do this, then I'll pay you this. And there doesn't have to be an acceptance there. It just is acceptance through performance. Then there's the 4 elements for contract formation. We looked at mutual assent, which is broken up by offer and acceptance. There are specific scenarios for when an offer is valid and specific scenarios in which an acceptance is valid. Then we looked at consideration. What is consideration composed of? What are items that aren't sufficient for consideration? What are substitutes for consideration, like reliance and restitution or unjust enrichment theory? Then we looked at capacity, so who has the capacity to even enter into a contract? Then we looked at legality, which is the final look to see if a contract could be void or voidable due to illegality. Then we looked briefly at the statute of frauds. What are the categories of contracts that require a writing and signed by the parties? Now, for this class, we looked at performance, discharge, and breach. And we looked at when a contract terminates due to performance, terminates due to agreement by the parties, or terminates by operation of law. Finally, we looked at instances in which mutual assent could never exist, and that would be fraud, misrepresentation, mistake, duress, and undue influence. Hopefully, just from going over this, you now have a really good understanding of what contracts means, and this is very useful for your work as a financial professional, because not just helping a client, you might enter into your own contracts. All right, see you next class.